You might feel this week like you're stuck in some kind of a time warp.
It's the political issue that does not go away.
Yet another challenge to the ACA.
The biggest threat to the Affordable Care Act is, once again, the Supreme Court.
Court challenge targets the tax credits that make the law viable.
The thing that pretty much pays for all of it.
The subsidies are key to keeping costs down.
The argument being made rests on something of a technicality.
A little more than a typo.
It was sloppy drafting. If the court were to strike down the subsidies,
you will have stories come out of people whose lives will be essentially ruined.
Taking money out of people's pockets.
Removing health insurance for more than 5 million people.
it would be very disastrous.
We're going to have a successful open enrollment.
Everything old is new again.
Healthcare.gov website is now up and running.
Simpler, faster, and more intuitive.
Officials have promised an improved experience.
The House, I'm sure, at some point next year, will move to repeal Obamacare.
Do everything humanly possible to repeal Obamacare.
It's saving lives and it's reducing the deficit. I don't know what more you would want.
The Supreme Court has decided to take another look at the Affordable Care Act. The court will consider whether Congress intended to provide subsidies to purchase health insurance to everyone who qualifies or only to people who qualify in states that have set up their own health care exchanges, not the federal government exchange. This summer, 2 federal appeals courts ruled in 2 different ways on that question. The Fourth Circuit Court of Appeals in Virginia ruled unanimously that lawmakers clearly intended for everyone who qualifies to be eligible for the subsidies. But the D.C. Circuit Court of Appeals ruled in a 2-to-1 decision that the government is only authorized to provide tax credits for insurance purchased on state exchanges, not on the federal exchange. Only 16 states have set up their own health insurance exchanges. Robert Pear of the New York Times reports, for people who obtained insurance through the exchanges this year, subsidies reduced the average premium by more than 75% to $82 a month from $346. About 4/5 of the people buying insurance on the exchange qualified for subsidies this year. If the court blocks payment of subsidies through the federal exchange, the ruling could cut off financial assistance for 4.5 million people. The Supreme Court is expected to hear the case as early as February. Joining me now, Nicholas Bagley, professor at the University of Michigan Law School. He previously worked as an attorney with the appellate staff in the Civil Division at the U.S. Department of Justice, and Julian Epstein, former counsel for the House Judiciary Committee. I just want to read the legislative language of this that has created this problem with the courts. It actually says that these subsidies are available, and there's a lot of technical language that precedes it, but to people who enrolled through an exchange established by the state. And Julian, that's the problem. The Democrats are all saying, look, I mean, an accurate drafting of that line would have said established by the state or the federal exchange. It would have included that. A lot of people referring to it as a drafting error, the kind of thing you and I have seen many times in legislative language, especially bills like this, Julian, that are rushed through, as this one was, with a lot of hasty drafting at the last minute.
Right. After Senator Kennedy's death. Yes, that's right. The plaintiffs, the people that oppose Obamacare, are resting their case solely on that one provision. The problem is that shortly after it in the state, and that provision was drafted very badly and sloppily, admittedly. The problem with their argument is right after that provision, the statute makes clear that the federal subsidies step into the shoes of the states if a state fails to establish an exchange. Secondly, it's very clear to everybody that has looked at the drafting of this issue in the legislative process that Congress had to have intended that the federal exchanges be eligible for federal subsidies, because the entire system doesn't work unless you have subsidies for the middle and low income folks. In fact, the entire program will collapse if this case is actually successful in the Supreme Court. Third, and you and I discussed this in July a little bit, CBO, which is regarded as the fair arbiter of kind of how laws ought to be interpreted, particularly with budget implications, they scored this bill as if the federal exchanges were eligible for tax subsidies. And four, the time-honored tradition here, and the time-honored legal rule is to give deference to agency interpretations, and clearly here the HHS and IRS are interpreting the provisions here, particularly the ones I just outlined, as clearly intending for Congress, by Congress, to have the federal exchanges eligible for the subsidies. If the Supreme Court is successful here, this will be, I think, the merits are so weak on behalf of the plaintiffs. If the conservatives on the Supreme Court are successful in overturning the law, and this is effectively be an overturning, this will be the most activist decision since Bush v. Gore, without a doubt.
Nicholas Begley, isn't it possible, I mean, Julian, I think, is echoing there a lot of concern that Democrats and supporters of the bill have, is that the Supreme Court, obviously they voted for cert on this. That means there's at least 4 votes that are interested in evaluating this question. We don't know which way that means they're going. Is it possible that they took this case, and they took the Virginia case specifically, that's the one that supported the Democrats' view, in order to actually solidify that they looked at the landscape out there and thought, hey, we'll probably be getting a bunch more of these on this exact thing moving through other circuits. We might as well grab this now and lock it down now, and they may very well lock it down in the way that Democrats say they intended the legislation to read.
It's possible. You never know, given that all of these debates happen behind closed doors, but I think it's very unlikely. If the left wing of the court were inclined to solidify this, they wouldn't need to take the case. There was no split in the circuit courts. The D.C. Circuit decision, which had struck down the tax credit rule, had been invalidated by the full court, which has agreed to rehear the case in mid-December. And the good money is that the full D.C. Circuit will flip that panel decision, meaning that there wouldn't be any split. So the only reason to take the case in the absence of a split is because at least 4 members of the court are at least concerned that the Fourth Circuit may have, in their lights, got it wrong. That means, at least as by my counting, that they just need to pick up 1 more vote in order to potentially invalidate the tax credits.
We actually have a recent book on this subject called Judging Statutes. It is written by Robert Katzman. He is as high a judicial officer as we have, just below the Supreme Court. He's the chief judge of the Second Circuit Court of Appeals here in New York. And he's writing about how the courts should judge statutes. This is what he says about this kind of case. Judge Katzman says, what I think is critical for courts, discharging their interpretive task, an appreciation for how Congress actually functions, how Congress signals its meaning, and what Congress expects of those interpreting its laws. Although in a formal sense, the legislative process ends with the enactment of a law, for the judiciary, understanding that process is essential if it is to construe statutes in a manner faithful to legislative meaning. And Julian, it seems that if the Supreme Court were following the guidance that Judge Katzman has here in his book about judging statutes, that clearly all the evidence that we have in the legislative and rhetorical record of this process indicates that everyone, including the opposition to the bill, expected that these subsidies would be available no matter whether your state created an exchange or not.
Right, and what the judge is articulating there, and you summed the case up very, very well, Lawrence. What the judge is articulating there is known to some as a rule of statutory construction or a rule of judicial constraint, which is if the court can interpret something in a way that upholds the statute, if there are provisions where there may be some conflict, the court ought to try to find a way for the statute to be valid. Here you just have one ambiguous provision that you cited in the setup piece, but where it's unclear whether the tax subsidies apply to the federal exchanges. But beyond that, you have multiple provisions where Congress is very clear that they want these tax subsidies for the federal exchanges. Again, this entire statute doesn't make sense without the federal subsidies for the federal exchanges. And again, as I said when we started, the CBO clearly interpreted the law as requiring subsidies for the federal exchanges. So the case is just kind of overwhelming, which again leads you back to the conclusion. If what the conservatives are trying to do here is got to be the most activist effort we have seen since Bush v. Gore. It's just there are very, very few people in the legal community who are kind of not vested in this case who believe this case has much merit one way or the other.
Nicholas Begley, after big, complicated bills like the Affordable Care Act and after many rather small bills, we always, at some point, soon thereafter, passed something that they called technical corrections. And this was done constantly, and these were routine bills, as Julian knows, passing through both bodies. And they recognized that there would be drafting errors in legislation, there would be interpretation complications at the agencies, and they needed to technically correct the legislation. And very commonly, technical corrections bills would get votes even by people who opposed the original legislation because they just thought, well, you know, if there's a leaky pipe in this house, we should fix it, you know, even if we didn't want to build the house. If we needed to do technical corrections bills, it seems to me we did them because we were afraid of exactly this kind of case that left uncorrected a technical error in a law, in a sentence of a law, could be brought to the Supreme Court to, in effect, remove that provision of the law.
I think that's exactly right. Right now, in this current political, kind of toxic political climate, it's very hard to see Congress coming together to make a technical correction of the kind you imagine. But they could fix this, Congress could, with a single stroke of the pen. It'd be an easy fix, but it's one that the Republicans in Congress don't want to make. And the end result could be depriving 4.5 million people on exchanges in states with federally established exchanges of access to subsidies upon which they depend to purchase their health plans. So it's exactly the kind of catastrophic outcome that you'd think a functional political process would allow us to avoid.
Julian Epstein and Nicholas Begley, thank you both very much for joining me tonight.